Let's just make sure you folks can hear me okay. 1 second.
The conference is now in conversation mode.
Can you all hear me okay?
Yes, I can hear.
Good.
Yeah, it's clear.
Thank you.
The conference is now in presentation mode.
Okay, very good. Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly, every other Thursday phone call. We have been doing this for the community, with the community, for a couple of decades, maybe a little bit more than that. We'll try to answer our questions to the best of your questions to the best of our ability, but this does not create an attorney-client relationship. Remember that all the disclaimers you heard when you logged into the call apply. I'll first answer the questions that are marked as frequently asked questions. I'll invite input or questions that follow on those questions. Nothing new. Once we answer all questions, including the frequently asked questions and non-frequently asked questions, we will get into new questions if time permits. With that, let me begin by going to the first two questions. I think I have marked only two questions today as frequently asked. It's important for people to understand the impact of criminal cases on anybody who is on a visa status. Whether it is non-immigrant visa, even green card can have consequences if you get convicted of a crime. There are basically two kinds of crime. There are crimes that are misdemeanors, where the punishment, I believe, is up to a year. I think if it becomes 1 year and 1 day, it becomes a felony. And felonies are serious crimes. So there are two categories of crimes, misdemeanors and felonies. And there are also two categories of crime under immigration law, which are crimes of moral turpitude. Actually, there are more than that. But let's just say that crimes of moral turpitude, where there's some element of cheating involved, and other types of crimes. There are also some crimes that are called aggravated felonies. There are drug-related crimes. All of them have different consequences, and multiple convictions have, again, different consequences. So whenever you run into a situation where you have been charged with a criminal offense, first of all, it is always a good idea not to speak to anybody except to your own lawyers. The government is supposed to, whoever the arresting authority is, they are supposed to wait for you to get your lawyer to come and talk with you before they start talking with you. When you get a criminal defense counsel involved and you're on a visa, it is also a good idea to get the defense counsel to get an immigration lawyer involved. And this is where the crux of the matter is: what kind of immigration lawyer should you get involved? I recommend getting an immigration lawyer who knows deportation laws in the state in which the crime occurred. Any lawyer can help you with the immigration aspects, but a local lawyer who deals with the local criminal statutes would be a better fit for crimes in the local jurisdictions. So that's what you should do. If you ever get arrested, stay quiet, wait for your lawyer to arrive, get a lawyer, and preferably get them to hire also an immigration lawyer. Most criminal defense counsel work with immigration lawyers, so they probably would have their own referrals. Okay. Now, there are several issues here that are not normally encountered even by criminal defense counsel. For example, under immigration law, the fact that you have your record expunged doesn't matter. Even if the record is expunged, you have to reveal that you were arrested, convicted, etc. You can't get rid of that requirement, even if the record is expunged. Second thing you have to remember is that what would not normally be a conviction under state law may be considered conviction under criminal defense, under immigration law. So for example, if you plead a certain way, it may not be, I'll give you an example. Let's say I say, okay, I plead guilty. When the judge says, okay, since you pled guilty, I will not enter a judgment until 6 months. And if in 6 months your record is clean, we will dismiss the case. Now, technically under state law, this is not a conviction because the judge has not entered a conviction. However, you pled guilty. Under immigration law, that is a conviction. So be careful with these issues. The issue that we have before us is criminal misdemeanor. What is the impact on an F1? So they were working, the writer, the person who wrote this, they were caught doing illegal distribution of cigarettes to underage people. And under Ohio state law, they paid the fine, they pled guilty. Will this affect my OPT EAD card because I'm going to apply in May month? Well, you have another problem, and it's a very big problem. Forget about the criminal law. You might be okay there, but I would have you contact an Ohio lawyer who does deportation cases. Get an opinion from them. I don't think there should be a problem, but don't take my word for it. I think if you have only one crime, you should not have any major consequences. But the fact that you were working without authorization means that you violated your status. And that's a problem for continuity of your F1. And if your F1 is not continued, you will be considered out of status and you will not be entitled to your OPT. So remember that. Can I go and return from my home country? Before you go, definitely take advice of an immigration lawyer, a local immigration lawyer who does deportation cases. Now, would you be able to return on that visa and the student visa? I think you should be. I don't see any reason why not. But would you qualify for an OPT? OPT requires you to be in status for 1 academic year, 2 full semesters. So you may have to discuss this with your DSO. I don't think there are going to be any long-term issues, but again, subject to advice of the local counsel, I think you should contact a local lawyer. And typically, what you should keep is a certified copy of the final disposition. Okay, whatever way your case was disposed, which is in your case fines. So action item, get yourself a lawyer, talk with them, an immigration lawyer who does deportation work. I don't think there's an issue, but let's get that confirmed. Second thing you want to talk with you want to talk with your DSO. You should disclose what happened and make sure that the continuity of 2 full semesters is maintained. Personally, I think you have a problem because of violation of status. Okay, so if you have any follow-up question on this discussion, press *5 on your phone. No new questions. If you have a follow-up question on this discussion, press *5. Okay, let's go on to the next frequently asked question. So this has several issues: protecting immigration status, traveling with advanced parole, divorce proceedings, and being an entrepreneur on an H-1B visa. Let's see how many we can cover. So your I-140 has not been approved, but you received your employment authorization for 2 years along with advanced parole. Is it okay to travel to India for 2 months, or for how long staying from the USA is valid on EAD? Okay, first of all, when you travel outside the United States and you stay out for too long, even though there is no law that says you can't stay out throughout the life of your advanced parole, I would be concerned, because the question could be, do you really have a permanent job in the US? If you do, how can that employer allow you to stay for that long? So can you stay outside for 2 months? Sure. And you're staying outside not on your EAD, you're staying outside on your advanced parole, because that's what enables you to come back. EAD allows you to work, but advanced parole allows you to come back. Do I need to worry about having a valid visa when coming back, or just advanced parole? So the law is, if you return to the same job that you were doing on H-1B, even though you used your advanced parole, you are still considered to be on H-1B. 3, Prior to getting green card EAD, I was on H for EAD. I may seek a divorce. Now that I have green card EAD, will divorce affect my current status or upcoming green card? I'm assuming that the green card was filed by you and not your wife, so the divorce has no effect on you. Last question, I've been an owner of an Inc. company, I assume that's an incorporation, while on H4 and H4 and H4 EAD, but I haven't taken any profits or pay stubs except for signing on company tax returns. Now, I don't think it stops you from getting your green card, but I would be a whole lot more comfortable if you had your lawyers look at the transactions you have done while you were an H1 entrepreneur, because there your activities are severely limited. However, if you have an H4 EAD, you can do pretty much anything employment-wise. Does the situation, okay, since I've already received green card EAD under the EB3 category, I should stay positive that I would receive the green card. So I don't see any obvious violation of the law. I'm just suspicious of that time you were on H1 and had your own company. The only time you're completely free is when you were on H4 EAD. You could have done anything. Okay. *5 if you have a follow-up question on this. *5. No new question. Okay. There is a question from area code 925. Okay. Area code 925. Where are you calling from?
Yeah. Hello. Yeah, I'm calling from California.
Yes, ma'am. Yes, ma'am.
So my question was just basically, what are what could be the dangers of traveling back on a advanced parole? Say I'm on an H4, my son is on an H4, and we all have the APAD from the EB5 application.
Okay.
So we plan to come back on the H4 status itself, but sometimes, we hear that it's dangerous to travel on your HP because, and now with no stamping available, dates available, I want to try to use that to go to India and come back. So is it dangerous to?
No.
Are there any issues?
I don't think so. For your case, I would be okay with you coming back in advance parole for a couple of reasons. It is a lot easier to get an H4 visa stamp than it is to get an H1 visa stamp. So if in the future something goes wrong with your green card and you have to convert back to H4, all you have to do is go to any of the consulates anywhere in the world where they are taking visas from non-natives and get your H4 stamped and come back. It's pretty easy, right? So H1 is more complicated because you've got to get an H1 approval first. Only then you can go get your H1 visa stamped. So I think you should be okay traveling on an advanced parole. All right?
Okay, and just one more. So if I have my current H4 stamped and my next one is approved and I go to India, I can just come in on my the visa that's valid till August, right?
You should talk talk with your lawyers, because I'm talking in a very general sense. I can tell you this.
I understand.
You can enter back into the United States anytime during the life of that visa. Once that visa expires, the fact that you have an approval of another H4 doesn't mean anything. To enter the US, you need either advanced parole or your H4 visa stamping. Okay?
Okay.
Good luck, ma'am.
Yeah, thank you.
You're welcome.
Yeah, thanks.
Okay, let's go on to the next question. And this one is from Pushram. Concurrent filing of Form I-140 and 485. With respect to H-1B stamping in India, if my employer cannot get an end-client letter, what are the best alternative documents? That's not something I can tell you in a 30-second discussion. You basically have to prove the job description, the nature of the employer-employee relationship, the duration, and the degree required. How you prove it could be a combination of many different documents, not just one. It could be master services agreement. It could be, along with that, they have job orders or work orders that might contain that information combined with a letter from a manager. So there's several things you could be doing. Basically, you have to prove the job description, the degree required, and whatever else I had mentioned earlier. The job description, the degree required, and the employer-employee relationship, as well as the duration of the job. Those are the 4 or 5 things. Okay. So your USA employer A applied for a green card in EB2 with approved I-140 2014 priority date. My H-1B visa rejected during stamping in 2016. I'm currently in India working for employer B. Now my priority date is 2014, which is eligible to apply next month. While I'm working for employer B, physical location in India, can employer A apply for 485? No. You have to be in the United States in a legal status, not just a tourist status, but something solid that allows you to stay in USA for a longer term than a tourist visa. And entering USA on a tourist visa just to apply for adjustment of status could be considered to be fraud. So watch out for that. But you can't file 485 while you're outside the United States. Then your next question is, how can my employer A file for the next step after I-140 EB2? Well, you're not working for employer A. We have many frequently asked questions. Just go to immigration.com, look at the frequently asked questions under I-140. I have discussed this issue many times. Briefly, the problem is, if you left that employer, how is it that you're going back? Do you really have the intention to work for them, etc., etc.? These are the issues that can be raised. My employer's H-1B rejection in 2016, does it affect my green card process? Well, I don't know what the reason for the denial was. If you're on the phone, press *5. If you're on the phone, press *5. I would like to know the reason for denial. So let me put it to you this way. Unless it was some fraud or some misrepresentation made by you, normally an earlier denial should not be a problem for a subsequent green card. H-1B denial doesn't by itself create any problems for you. *5, if you have a follow-up question on this, *5, press *5. Okay. Then we come on to pile 786. Using I-140 from a previous employer. I used to work for XYZ company. They filed my green card, got I-140. I left them 5 years ago as a senior project manager. And I used to work in ABC technology, some technology, let's say SAP. They have not revoked my I-140 and I joined them again on a different designation. Yeah, I think you would have a problem there. If you want to continue the same green card, your job has to be the same. Okay. You can use the priority date from that old I-140. But you might have to restart your green card with a new company if you don't want to join the sponsoring company. And you can't have your immigration attorney file your green card. It's the employer who has to do it. It's the I-140 is the employer's documentation. And 485 must be accompanied by a job offer. And the job offer has to come from the proper person in the company, the old company. So there's a lot of possible complications here. Do I need any document or support from XYZ company to file 485? Sure. You need to be able to prove that they have a job offer open for you. Yeah, different destination, different technology, everything can affect your green card. How can I check my I-140? I can't explain the whole process. I don't have time for that. We have a lot of ground to cover. You can talk with your own lawyers, and if you don't get satisfactory answers, you can either set up a consultation with me, go to our website and just do a request for, there's a contact us form on the website. You can just set up a consultation through that. Okay, but I think most of the process is pretty simple. It's not that complicated. PERM, then I-140, then 485. Star 5. If there's a follow-up question, press star 5, please. Okay. Can we refile I-140 with the same PERM if employer A withdraws I-140? You can't refile I-140 through a different employer. So you got your I-140 from employer A, then you moved out 3 years later. Employer B applied for PERM, but it got denied. Now planning to move to employer A. Oh, so you are going back to employer A. Okay, got it. Can we file I-140 with the same PERM? You can certainly try. I have done that in the past and it worked. I think it's worth trying. Because remember, the first I-140 has to be filed within 180 days of when the PERM expires. But once you have filed one in a timely manner, even if the I-140 is denied, you can file a subsequent I-140 outside the 180-day limit. Okay. Star 5. If you have a follow-up question on this, press star 5. All right. Question number 7. EB2 I-140 is approved September 2014 with March 2013, I guess, priority date. Beginning green card processing under EB3 under new employer. Will I-140 be abandoned? So you got the I-140 approval. Now the current employee, you left that company, current employee has started the green card under EB3 category. The previous one was under EB2. Current visa bulletin has my priority date current in the final action section. No, I don't think that's accurate. If the final action date is current for more than a year and the applicant does not file I-485, the USCIS consider the application abandoned. I've never heard of that. That can happen if you are doing NVC visa processing, if you are doing PERM or green card through consulate. But if you are filing for adjustment of status, the fact that you have not filed for an adjustment of status for a year or 2 years does not nullify your I-140. Okay. Will I retain my priority date under new I-140? No, there's no abandonment. I don't see any reason for you to worry about that. Star 5 if you have a follow-up question. Press star 5 if you have a follow-up question. Okay, let's go to question number 8. So there's a misspelled last name on AP. Can we travel on that? Both EB2 and EB3 are pending. Yeah, you have started the procedure for correction. I personally think you could travel. When coming back, they could put you in secondary inspection. I would just take a letter from your lawyer confirming that they have asked for correction. I think you could travel with the advance parole. You can also do another thing. You can contact the Customs and Border Protection. They are actually one of the few agencies that do answer their telephones. So you can ask them, is this going to be a problem? Let's just find out what they say. Not a bad idea. If I use my EB3 AP, how is it going to impact my EB2 and EB3 process? I don't think it should affect the process. Will I be getting another EAD and AP? Probably not. I think they just deny an EAD and AP request if it is made duplicatively. They allow us to file 485s more than once, but they won't issue you EAD and AP more than once, as far as I know. *5 if you have a follow-up question. Press *5. No new questions, only follow-ups. Area code 503. 503, where are you calling from?
Yeah, I'm calling from Atlanta. Actually, I have similar kind of typo on a green card, Rajiv.
Okay, so if you have a typo on green card,
So can we try?
yeah, you can do an electronic correction online. Okay, so if you just
Yeah, we submitted.
right. Can you travel?
Yeah.
What you can do is take your passport in, make an InfoPass appointment, take your passport into the local USCIS. They will stamp your passport. That stamp is as good as having a green card. It's called EDIT stamp. Oh, sorry, ADIT stamp, ADIT, I think. Okay.
Okay.
So get an edit stamp and you can travel with that. Okay.
Okay.
Good luck,
Thank
sir.
you.
Good luck. Area code 925. Where are you calling from?
Yeah, I'm calling from California.
So
I had a question that like the multiple advanced parole. So my husband applied along with AOS, and he then traveled to India before getting the advanced parole card. So obviously the lawyer later on told us that means now that's invalid. So he applied again. But in the meantime, they sent him an AP and EAD card.
Okay.
So
yeah, I would not use the AP, but if you returned on an H1 or H4, you can use the EAD. AP has to be reapplied. Okay.
Okay.
Good luck.
Okay. Thank you. So he just applies again then.
Yes, ma'am.
Okay.
Bye-bye.
Thank you. Thank you so much. Yeah.
You're very welcome. Okay, now we come to question number 9. H4 extension, change of status pending, and F1 status. I'm an H4 expiring August of this year. Got into dental school, which is a 2-year program starting from July. Already filed my change of status from H4 to F1. Yeah, see, the current thinking of the government is, even though there's nothing in the regulations as far as I know about this, but there is a page on the uscis.gov website somewhere that says if you have applied for a change of status from status X to status Y, and status X allows you to go to school, you can start school even though your request for change of status is still pending. So because H4 allows you to study, I believe you should be able to go to school. You can double check with your DSO. I don't think it should be any problem. And if you have an H4 and F1 pending, H4 extension and F1 change of status pending, just make sure you withdraw the one that you don't want as quickly as possible. Okay. The only complication is a delay in withdrawing your H4 extension that could then potentially, although I would argue against it, potentially land you back into H4 status, although you want to be in F1. It is always possible that you could get an H4 approval even though you asked for a withdrawal, but that should not hurt you, because as long as you have the proof of asking for withdrawal, government should make the withdrawal effective as of the date they received your letter. Okay. *5 if you have a question. *5 if you have a follow-up question. Okay. So next question, number 10 is traveling to India while spouse's H4 visa is pending. Got my H1 extended through my... Oh, please be quick about asking your question. Okay, area code 216. I have to go back to that question. Area code 216, where are you calling from?
From Ohio. Sorry for delay.
No worries.
My concern is that my DSO is suggesting me to do H4 extension for safe side.
Okay.
But as I talked in question, if I got H4 approval, even though I sent withdrawal, then how
Yeah,
I
but
can proceed
I don't see the point of doing an H4 extension if you have an F1 change of status pending. But it is up to, I mean, this used to be the old law. The laws changed. The government's policy changed. They don't expect you to maintain status till the date your F1 is granted any longer. They changed that about 6 months ago. So tell the DSO to look at the current law and then tell you. Tell them that there was a lawyer who said that that rule has changed. Now you don't have to maintain status all the way till you get your F1 approval. It is enough that when you filed your F1 change of status, you were still in H4 status. So you should not have to do an extension, but double check with them, okay? I think they are giving you the old law.
Okay.
All right.
Okay, thank you.
You're welcome. Okay, so it's hard to keep up with immigration law. It changes so rapidly and so frequently. It's easy to miss something like that, even though you do this for a living. So then the next question is again, question number 10. Traveling to India while spouse's H4 is pending. I got my H1 extended through an employer. We filed for wife's H4 separately online. We've got the receipt notice. 5 months and it's still pending. She has to travel to India. So what happens is she can travel. That's not a problem. But she'll have to get an H4 visa to come back in. And the 539 will be cancelled. And that's okay. If the 539 gets approved while she's in India and USCIS calls her for biometrics, you just have to tell them that she's already left the country. And that should be okay. She has to get an H4 visa and come back. *5 if you have a follow-up question. Press *5 if you have a follow-up question on this. Okay. Number 11. Now this is complicated and I don't know why this question was not answered. He says or she says they had posted it last time. There must be a reason I did not answer. I'm being hired by an automotive supplier company headquartered in Ontario, Canada, and US location Michigan, Detroit. I'm a Canadian permanent resident, still an India passport holder, and you will be living across the border in Windsor. You want to live in Canada and work in the US. 70% work from Ontario. Can they put me on their Canadian Ontario payroll? You know, this is where things get interesting. I would rather have you talk with your lawyers to decide. Can this be done? I think it can be. Can you be working in Canada and get paid in Canada while you're there? And can you be working in USA and be paid in USA while you're here? The answer is yes. So the choices are only two. You get paid in USA your entire time, or you get paid in Canada while you're working in Canada, and you get paid in USA while you're working in USA. I think that should cover it, but please have your lawyers customize this for you. *5 if you have a follow-up question. *5. Okay. Let's go on to the next one. Number 12, sponsoring green card for parents. Parents are in the US on tourist visa. My sister is in Boston. She's a US citizen. Currently, parents are staying in Texas with me. Can my sister file for green card for parents while they're staying at my place? Sure. I don't see why not. Can my parents get their medical examination done in Texas even though their application will be sent from Boston? To the best of my knowledge, yes. Yes, they can. Star 5 if you have a follow-up question. Star 5. Okay. Question number 13th. Marriage-based green card and the 90-day rule. Well, technically, there is no longer any 90-day rule, but we still worry about the underlying policy. What is the underlying policy? If somebody comes to the US saying, I'm going for tourism, but within a couple of days they file for a green card and adjustment of status, it sure looks like they lied when they entered on tourist visa. So that basic principle is still there, but the 90-day rule has been taken off. The 90-day rule does not apply to I-130. It only applies to AOS. And you can always go in as a co-sponsor, and I don't know what your tax situation is. You can go in as a co-sponsor if required, as long as you're a green card or you're on F1 OPT. Okay. So I don't remember exactly how they aggregate income, but I believe the family income should be counted if you are married filing jointly. Double check the I-864. I don't remember exactly the provisions off the top of my head. And of course, you can always get a joint sponsor as well. Star 5 if you have a follow-up question. Press star 5. Okay. Canadian citizen applying for TN visa. This is number 14. My wife and I entered USA on B2, applied for change of status B2 F1. I left country, abandoned my F2. Now I'm a Canadian citizen, plan to enter USA. Scenario 1. If TN is applied through employer A and I enter USA as a visitor, if I apply for TN when in USA through employer, will I have a problem? I am very reluctant to advise people in this situation to change status within the United States. I think it's a lot easier and better for you to just go to the border. If I'm approved for TN, can my wife apply for change of status to TD? Indian, given her F1 is still not approved. Well, remember I just mentioned that the rules have changed. She should not have to maintain her status as a visitor all the way to the time when the student status is actually approved. Although I do see one problem, entering on B2 and then applying for F1 does not smell good. It does feel like you intended to do that even before you entered, and that can be problematic. Okay. If TN is applied at the port of entry in Canada, will I have any issues getting TN given I extended and later abandoned my F2 in USA a month ago? I would need to know a lot more about your facts. I can't really comment whether you're going to have any problem or not. Star 5 if you have a follow-up question. Press star 5. Okay. All right. Folks, anybody has any question? We've got about 23 minutes. So anybody has any question, press star 5. 1, 2, 3, let's see, 4, 5. Okay, that's not too bad. That's about 4 minutes per question. Plenty of time. Let's see, in the order that you logged in. Let's go to Illinois first, area code 815. Illinois, go ahead, please.
Yeah, sir, I have a 19-year-old son who is using the EAD we received from under EB3 for an internship. And if my EB2 date becomes current under final action date, can we refile the I-485?
Refile the I-485. Let's go back to the original question. He's 19, right? He's not 21 yet.
Yes.
Okay. So what you're saying is, if the dates become current, we file 485 for ourselves. I'm sorry, I didn't catch the...
No, for including him on the EB2. Because we got EAD under EB3.
Can you file another 485? Is that what you're asking me?
Yeah.
Yeah,
EB2.
you can even interfile. You can the way I'm looking at it, because he's still under 21, if the final action dates are current, dates for final action are current, you can ask for an interfile, which would be faster, I think, from EB3 to EB2. And at that point, right now he has his 485 pending under EB3, right?
Yes.
I think you can move it to EB2 as far as I know. I don't see any problem with it.
So if I do interfile, does his age lapse?
No, because he's still under 21, right?
Correct. And I don't know, some people saying that he will not get any 485 receipt.
No. What I'm thinking is, you may be confusing those cases where under EB3 he is protected, but for EB2 he's over 21 already. Then you would have a problem.
No. EB2 is not protected. EB3 is not protected.
You said he's 19 years old, right? Currently.
Correct, but we file under filing date, not his final action date never become current.
Oh, it has not become current. So if the EB2 final action dates become current, that I think you should just refile the 485. That makes more sense. Although I think he might be protected, but this is such a complicated area of the law. I don't like taking chances with something like this. I would just file a new I-485.
But is it okay if he uses the EAD, still filing the 485?
That should be okay. Okay. Actually, if you go to my blog and read the 4th or 5th entry, which talks about interfiling, the government has answered this question. Somebody asked, our organization, American Immigration Lawyers Association, asked them, what if we have already used the EAD, can we still file 485? And they said yes. Okay. Good luck.
Thank you.
You're welcome. Okay, let's go to the person in the order they logged in. This is Oregon. Area code 503, I think. Yes. So 503, please go ahead.
Yeah, Rajiv, again, this is from Atlanta. So my green card came with a couple of
what? Sorry?
Yeah, couple of letters mistyped.
Right,
so
right.
We submitted online, electronically we submitted to correct it.
Yes.
But the USCIS says like it's been sent, document been sent, but we didn't receive anything. So we raised it to Ombudsman, and Ombudsman office came back saying that the case is in process. So in the meantime, we submitted I-90 to correct the name. Good. Mistype of.
Good.
So that application is still pending, and it is yet the decision is yet to be done.
Yeah.
But couple of last week we got stating that it's been done. The case is completed.
Okay.
But we didn't receive anything.
Okay, so I just told you what I told you. You just do the same thing. Just go to the make an InfoPass appointment. Get them to stamp your passport for travel. Okay. Good luck.
But for the case, what we can do, like
I don't know the answer to that question. If the documents are lost in the mail or something, you have to figure that out with the USCIS. That's just a technical, just a logistical issue, nothing to do with the law. Just open a service request. They'll take care of it. For traveling, just get an added stamp to travel. Okay.
Okay. Yeah. Sure. Okay.
And also for working, that can be used as a green card. That's proof of green card. Okay.
Yeah, we received the green card. Yeah. Okay. You got it. Yeah. Thank you.
Good luck. Yeah, I know you received the green card. It had errors. So what I'm saying is, you can just get the added stamp, and that works both as proof of your green card for travel as well as working. Let's go to California, which is area code 424. 424, go ahead please. 424.
Thank you for the opportunity, sir. Sir, I'm calling from Phoenix, Arizona. So my question is, last time I entered the US was on H-1B, and that was 8 years ago.
Okay.
Later I converted to H-4 EAD.
Okay.
in October 2020, my wife, who is the primary applicant, downgraded from EB2 to EB3 to 140 amendment.
Okay.
And we received our AOS, EAD and AP, which we haven't used yet.
All right.
And if I travel to India and come back on AP or H4, will this have any impact if we have to do a new 140 or 485 in EB2 category?
I don't think so. And what I just told the gentleman before you, go to my blog on immigration.com, third or fourth or fifth entry has this information about interfiling from the USCIS and a conversation between American Immigration Lawyers Association and USCIS, where USCIS said use of advanced parole or EAD should not be a problem for your future 485. Okay.
So just a follow-up question. Only reason why we are in a confusion here is the interfiling does not have any tracking, and some of the lawyers say that without tracking we don't know what is happening.
No, but if you have the proof of that request having been made, having been sent to the USCIS, that should be enough. And also, if you are doing an interfiling from EB3 to EB2, they will give you a receipt because you have to submit a supplement J. Okay, that's the new procedure, and that procedure is on that same blog entry that I told you about. Go to immigration.com, go to my blogs, which is the link is on the very top gray bar. Go to my blogs, read the third or fourth or fifth entry, which talks about interfiling, and USCIS tells you here is a new address, this is where we want you to interfile, and if you're going from EB3 to EB2, make sure you file a supplement J. We'll issue your receipt. Okay.
Okay. And if our dates get current and I'm the dependent applicant, and if the dates get current and my wife is here in the country and she applies for interfile, do I need to come back for interfiling also?
I do not believe so, but you can always double check with the USCIS customer service. They'll patch you through to a adjudications officer. I don't think you need to be in the United States to do an interfiling, but that question I have never really confronted, so I can't tell you definitively. If I were in that situation, I would check with the USCIS. Okay?
Okay, sir. Thank you so much for your
You're welcome. Good luck. Okay, we have two more questions and then we are done. Let's see. We have this one is from Nevada. Nevada area code 702. 702, go ahead please. 702, go ahead.
Hello, sir.
Hello, ma'am.
So, my question is also on the similar line. So, I downgraded from EB2 to EB3 through I-140 amendment, and I have my I-140 approved in EB3, and I also received my EAD and AP.
Okay.
Now, my question is, if my date gets current in EB2, I'm thinking to do a new I-140 with a new 485 instead of just doing an interfile with a new I-140, because my understanding is that if by having two 485s, I don't have to worry about, which category retrogresses or whichever gets carried.
I think so. I think there's certain advantage, but the point is, if your final action dates are current, you should do an interfiling in my mind, because there is some possibility you might get approved by September.
So what if it retrogresses,
Then you can always file. Look, if it retrogresses, you already have a 485 pending. So you want to see, the thing is, there is some advantage in having what we are doing for our clients. If we are filing right now, we are doing an interfiling because we are hoping, fingers crossed, that the cases get approved by September end before the next fiscal year begins, which is what the government has suggested to everyone. Okay, but as we draw closer to September, for example, if I hit July or August, I might think of just filing a new 485. Okay, but that's your call. I I can see the sense of filing a second 485, but I can also see the sense of just taking the chance of getting a quick approval.
Doing an interfile.
Yes, ma'am.
So if I have 2 485s, I don't have to do an interfile again in future.
No, ma'am.
Whichever category gets current.
No, ma'am.
Okay.
No, actually, the fact of the matter is, the fact of the matter is, if you have 2 I-140s approved and you interfiled from one to the other, if the one that you interfiled from gets current, they might still be able to approve your 485, even though it is attached to the category that is not current. That used to be their policy, but because they changed to this interfiling, like one of the things they said was, you can interfile from A to B and then you can't interfile again from B to A. That was not the policy earlier. They would let me keep my 485 floating, and whichever I-140 got approved and the date became current, they would give me that category. But things have become a little bit more weird now. A lot of these issues have not been quite addressed. What happens if one priority date retrogresses to which I had done the interfiling, but my own EB3 case is now current? Can you just use that 485 and give it to me? And they said, no, we won't. And I think that's wrong. But in any case, you can always file a new 485 for the category that then becomes current. Nothing wrong with that.
Okay.
So I don't see any loss here.
Got it. Thank you.
You're welcome.
Got it. Good.
Yeah, they don't make it easy for any of us, do they? And it's not really, and you can't even talk with people whose word you can trust. Okay, the next one is 925. That's California. California, you are the last call. Go ahead, please.
Hi. So basically, when we filed for an EOS, my daughter did not have an SSN, so we said, please give an SSN. And then she got a job on the campus in her college. So she got an SSN at that point. So now they have sent us 2 SSNs. So she's trying to get an appointment to go and meet and merge the 2.
Yes.
So, but the appointments are like back, she's got one.
Okay. Hang on one second. Hang on one second.
Yeah.
First thing you want to do is you need to put it in writing. Okay. So whether you send them a letter or an email, or even if you call them and document that you write down the details. I called them on this date, this number. This is the person I spoke with. This is what I told them. This is what they said. So that's the number one thing. Document it. Okay. Number 2, you can even contact your local congressman's office and say, I have this weird problem with Social Security. Can you help me? And they will.
Okay.
Good luck.
Okay. Fine.
All right.
Okay, thanks.
You're
Thanks
welcome.
a lot.
All right. Bye-bye. All right, folks, as I had indicated, this was the last question of the day. So I'll talk to you again in 2 weeks. Good luck and stay well, everyone. Bye-bye.